This is Colin O'Keefe with Wednesday's episode of LXBN TV. Last week, the Supreme Court handed down its ruling in Standard Fire v. Knowles, a case with major class action implications. Joining me to break down the case is Ronald Wick of Cozen and their blog, Class Action Defense Review. Ron, first, this case is somewhat technical as it involves closing a loophole used in many class actions. Can you explain for us in plain English what happened here and how the court ruled?
I'll try. In semi-plain English, what went on here was the Class Action Fairness Act requires that, provides that federal courts have diversity jurisdiction if a class action is worth $5 million. And what's happened is plaintiffs have begun to try to keep the case out of federal court and prevent defendants from removing class actions to federal court by filing with their complaint a stipulation or an affidavit that says, I promise that I will not seek more than $5 million in damages on behalf of myself or on behalf of the class. It's a fairly common practice in individual lawsuits where the diversity threshold is $75,000. The plaintiff will say, I won't seek more than $75,000 in damages, and that defeats diversity jurisdiction and allows the plaintiff to stay in state court. The problem with a class action is that the plaintiff isn't just binding himself in his own damages, but binding the entire class. And since no class has yet been certified, then the plaintiff doesn't speak for anybody except himself and is binding absent class members. There's a number of other federal courts have already said this practice is not okay. But the Eighth Circuit was sort of an outlier and allowed a number of these cases to go forward based on the stipulation, saying, okay, if the plaintiff promises not to seek $5 million, then the class can go forward and stay in state court. The defendant in this case, Standard Fire, had indicated in their briefing that this had become a real problem for them, particularly in Arkansas, that there were a number of cases like this brought by the same law firm in the state courts of Arkansas, in which they would go in, file these stipulations, keep the case in state court, and get some relief from the state court that would be very favorable to the plaintiffs, prevent discovery from going forward, or allow discovery to go forward on a mass scale before any dispositive motions have been decided, and basically force a settlement.
I see. And second, we've seen a wealth of commentary come across the LXBLog network from lawyers in many areas, so I think I have some sense of this. But just how impactful is this ruling?
It's a huge impact in terms of what might have been had the court gone the other way. I think it's an unsurprising result, and it was a unanimous decision. The Eighth Circuit's position is sort of hard to justify because if you allowed a plaintiff to file a stipulation like this on behalf of the entire class, it really could defeat the entire jurisdictional regime under the Class Action Fairness Act. But it certainly is, it's a huge victory for class action defendants, for businesses, because it basically ensures that they'll be able to get into federal court for large class actions.
Very interesting. It's a huge case and one that will have a big impact on class actions in the future. Again, that was Ronald Wick of Cozen. For more of his analysis on this case, be sure to visit classactiondefensereview.com, and for curated commentary on this case from the entirety of the LXBLog network, visit LXBN section dedicated to just this case by going to lxbn.com, searching for Standard Fire v. Knowles, and then clicking on that tag right there. Thanks for joining us, Ron.
Thank you, Don.